The final address of Peter Obi and the Labour Party to INEC has been received, and it spans a lengthy 42 pages. Let's focus on the three main issues they want the court to address. Notably, Tinubu's legal team is primarily defending against disqualification issues, certificate forgery, forfeiture of $460,000 as proceeds of narcotics trafficking, Shettima's double nomination, and other related matters. In contrast, INEC's defense revolves around non-compliance and the announced election results. Now let's delve into the core arguments. The Labour Party's legal team seeks the Presidential Election Petition Tribunal judges to determine three crucial aspects. 1. Are Tinubu and Shettima qualified to contest the presidential election based on the unchallenged facts and circumstances arising under Section 137, subsection 1D, Section 142, subsection 1 and 2 of the 1999 Constitution, and Section 25 of the Electoral Act, 2022-2. Do the documentary evidence presented to the Honorable Court, along with the unchallenged expert and technical evidence of the petitioner's witnesses, prove that INEC's non-compliance with the relevant provisions of the Electoral Act 2022 and its subsidiary legislations substantially affected the outcome of the questioned presidential election held on the 25th of February 2023. 3. Was INEC's declaration and confirmation of Tinubu as the winner of the presidential election held on the 25th of February 2023 invalid due to non-compliance with the provisions of the Electoral Act 2022, and by virtue of the mandatory provisions of Section 134, subsection 2b of the Constitution of the Federal Republic of Nigeria, 1999 as amended? It is essential to note that these are the main points the Labour Party wants the court to determine, but their petition also includes other reliefs they are seeking. The focus here is on the objections raised by INEC, which the Labour Party has addressed in this final address. Now, let's move on to Shettima's double nomination. Unlike the issue raised by the Allied People's Movement, APM, concerning Tinubu's allegedly invalid nomination, the Labour Party is concerned with Shettima's double nomination. To illustrate the differences clearly, the Labour Party's arguments rely on Section 142 of the 1999 Constitution and Section 35 of the Electoral Act, 2022. Section 142 of the Constitution discusses the nomination and election of the Vice President, stating that in any election related to the office of the President, a candidate must nominate another candidate from the same political party as their associate for the position of Vice President. The nominated vice presidential candidate shall be deemed to have been duly elected to the office of Vice President if the presidential candidate who nominated them is duly elected as President, following the provisions of the Constitution. Regarding the illustration of the four dates in contention: 1. The day Shettima wrote the letter of withdrawal to APC. 2. The date INEC claimed to have received the letter from APC. 3. The day Shettima was nominated as a vice presidential candidate of the APC. 4. The date on the withdrawal form with INEC. The Labour Party's legal team argues that Section 31 of the Electoral Act 2022 determines the actual date of a candidate's withdrawal. According to this section, a candidate may withdraw their candidature by providing written notice, personally signed, and delivered to the political party that nominated them, with the political party required to convey such withdrawal to INEC no later than 90 days before the election. Therefore, the date the candidate submitted the withdrawal letter to their party becomes irrelevant, since INEC is not yet aware. Even if the candidate delivered the withdrawal letter to their party on July 6th, it is still inconsequential until the party conveys the same letter to INEC, and INEC finalizes the filing of documents. Consequently, Shettima remains a candidate for Borno Central Senatorial District until the process is completed. Based on the presented arguments, the Labour Party's legal team contends that, according to existing judgments of the Appeal Court and the Supreme Court, a valid withdrawal, as per the Electoral Act, begins when INEC is officially notified by the party. In essence, the law does not recognize the date a candidate submitted the withdrawal letter to their party. Instead, it counts from the time INEC receives the letter. This ensures that INEC is aware of the candidate's withdrawal before the election takes place, preventing the candidate's name from appearing on the ballot. Moreover, the Labour Party's legal team argues that the respondents cannot rely on the Supreme Court's judgment regarding Shettima's double nomination. Across different courts, the decisions were based on the lack of a local standard by the PDP, and the courts never ruled on specific dates. Consequently, the Labour Party views the comments made by Honourable Justice Okoro in the judgment as obiter dictum, which are remarks not central to the main judgment and are therefore not binding on the court. Supporting this claim, the legal team cites cases like Amadi v. Nwagbara 2021 and Bamai v. State 2001. These arguments highlight the issue of INEC's alleged partisanship as a supposed neutral umpire defending both Tinubu and Shettima. The Labour Party questions how INEC can assert that Shettima withdrew his nomination when he wrote the letter to the APC. Without receiving the letter and other necessary forms for official withdrawal, INEC cannot be aware of the withdrawal and the process remains incomplete. Regarding a judgment cited by the Labour Party's legal team, Honourable Justice Emmanuel's interpretation of Section 31 of the Electoral Act during the Ekpe and Itangi 2019 case is noted. The justice held that a valid withdrawal occurs when both the candidate delivers the letter of withdrawal to the party and the party conveys the same letter to INEC. However, there appears to be a shift in this view. In conclusion, the Labour Party's legal team refers to the Supreme Court judgment that disqualified David Leon in Bayelsa in 2020. The disqualification was a consequence of a joint ticket with the deputy who forged his certificate. Similarly, if Shettima is disqualified, it would affect Tinubu since they are running as a joint ticket. Given these reasons, the Labour Party asks the Honourable Justices of the Tribunal to uphold their objection and consider all votes cast for Tinubu and Shettima in the presidential election as wasted votes. As the final address to INEC is extensive, the party refrains from further details in this presentation.